Over the weekend, Hudson County TV obtained a copy of a letter written by West New York Town Attorney Gilberto Garcia, stating that Deputy Mayor Silvio Acosta may have his fines abated at his Lincoln Place property, which are now over $500,000. He spoke to Commissioner Count Wiley and his attorney, Fernando Jimenez, to see if they thought Acosta would ever end up paying a cent to the town. The January 23rd letter from Garcia, addressed to the zoning board members but not the zoning board attorney, states that the fines leveled against Mr. Acosta by the former construction code official will not be pursued. The town attorney goes on to say that the town no longer has jurisdiction over the case, the Department of Community Affairs does, and the fines were never processed and therefore never made it to municipal court for enforcement. However, an email from the DCA's public information officer, Tamori Petty, seemed to contradict what Garcia said. We are not pursuing the fines issued by the town because this is the responsibility of the town. The Division of Codes and Standards has issued its own fines, which they usually do to determine how much should be collected based on applicants' compliance with the code. Commissioner Count Wiley and his attorney, Francisco Jimenez, heavily scrutinized the letter and criticized the zoning board for the way they have handled the Acosta matter as a whole.
Well, let's talk about the fines. I mean, what do you mean he hasn't rolled up the fines? I mean, as far as I'm concerned, there was a figure, an amount put down over $500,000 in fines. So I'm sure the amount of fines were assessed due to some violation in the building. And what's happened is right now, the violations again come back. Like I said, he sent them to the DCA. So what did he send to the DCA is my question. He had to send some kind of paperwork of the violations and what the fines added up to in that amount. And over the time, what I understand, this is also collected interest. It's up to $580,000 at this point.
First of all, the letter is written by Gilberto Garcia, who is the attorney for the governing body. He's the town attorney. The letter is addressed to dear sirs or madams, and it is to the honorable members of the zoning board. So Mr. Garcia is directly speaking to the board members through his letter. The letter doesn't copy the attorney for the zoning board. The zoning board and every other board has an attorney. And he addresses that he has spoken to the DCA, regulatory officer, but he doesn't mention who the regulatory officer is or when he spoke to him. He never mentions what the content of that conversation was. It does indicate that any outstanding fines shall be resolved as a condition precedent to this approval becoming operative. What they're saying here, if I'm reading this correctly, is that so long as the board finds that these conditions have been met, there will be no penalties and fines assessed. The question, though, is how can we guarantee that the public is going to have the appropriate representation of whether the conditions were met or not?
Another letter in question comes from current construction official Manny Fernandez. The letter, which is not signed or dated, concurs with Garcia's assessment that the DCA has jurisdiction in the case, even though the state agency says otherwise. Fernandez told Hudson County TV he did sign and date the said letter in late December, though he did not have a copy available to send over.
I'm John Heides with Hudson County TV. For more information, log on to HudsonCountyTV.com.